or the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 19-3098, United States of America versus Victor A. Brown, Jr., Appellant. Mr. English for the appellant, Ms. Carroll for the appellee.
Morning, counsel. Mr. English, please proceed when you're ready.
Thank you, Your Honor. Well, good morning. I said my name is Greg English. I was appointed by this court to represent Mr. Brown. I also represented him at trial. I'd like to initially turn my attention to count one, the possession of a possession of a firearm by a convicted felon in violation of 18 U.S. Code Section 922G. The prosecution claims at page 29 of its brief that the defendant waived objection to the knowledge of his status issue. I note, as we said in our brief, that the Supreme Court and United States v. Rakoff abrogated the precedent from every circuit which held that a defendant's knowledge of his status is not an element of the offense. The particular case in the D.C. Circuit was U.S. versus Bryant, of which we cited in our brief at page 28. Rakoff ruling occurred less than 3 months before the trial in this case. It added an element. The prosecution must prove that the defendant knew not only that he was a convicted felon, but that he had the relevant prohibited status. This was a relatively obscure issue. It was not one that was on the front page of the Washington Post. It affected a relatively narrow class of people. And the simple truth is I was unaware of the change in the law. I'm a solo practitioner. I read the journals and things that come out, but there's a lag time before the news of this case was disseminated. The prosecution was also completely unaware of this change. They were obligated, if they knew about it, to inform the court. They did not. In fact, as is normally the practice in the district court, the prosecutors drafted the instructions. If I had any objection to them, I do not remember. I don't believe I had a good faith basis to object to anything. I note that two extremely capable prosecutors with the government's resources, when I worked at Justice, there was an appellate section that would disseminate news of new cases that were important to the various sections. And there's certainly an appellate section in the U.S. Attorney's Office in this case. So neither of the parties were aware of the change, and an excellent judge was also unaware. And so I respectfully submit, in the interest of fairness, the court should consider this case on its merits, and also in the interest of judicial economy, because if the court rules that I should have been omniscient and should have known of this case immediately, which upset, standing precedent, that my client will immediately file a 2255, and the matter will come right back before a court to be litigated again. And here it's been briefed, it's being argued. I respectfully submit it should be resolved on its merits. Now, the prosecution also claims that
didn't the stipulation include the knowledge element?
It included the knowledge that he had been convicted of a felony, not that he was aware that his status of a convicted felon prohibited him from possessing a firearm.
Right, but there's a difference. No, but there's an intermediate one that you're skipping, it seems to me, which is he had been convicted of a felony. The question that Rahafe raises is whether he knew he'd been convicted of a crime punishable by more than 1 year, not whether he knew that being convicted of a crime punishable by more than 1 year means that he can't possess a firearm. That's a third one. Rahafe, as I understand it, was the second one, which is whether he knew he'd been convicted of a crime punishable by more than 1 year. And the stipulation at Joint Appendix 307 says exactly that.
Your Honor, clearly he knew he was convicted of a felony. But if I can refer to the Medley case from the Fourth Circuit, which I cite in the 28J letter at page 31, it says, "We hold that the failure of the indictment to provide proper notice, combined with the district court's failure to instruct the jury that it had to find Medley knew his prohibited status under the reasonable doubt standard, and the government's failure to present sufficient evidence on that point simply require reversal.
No, but knew his prohibited status means knew he'd been convicted of a crime punishable by more than 1 year of imprisonment. Not that he knew that that status meant he couldn't possess a firearm.
Your Honor, our position is the prosecution was required to prove just that he knew that he was a prohibited person, not just that. And Your Honor, I like to note that
I point you to in Rahafe on the Supreme Court report at page 2194. The Supreme Court defines right up front what they mean by prohibited status, or what they call relevant status. And they say that he fell within the relevant status, parentheses, that he was a felon. That's all. He didn't have to know that he was barred from having a firearm. The Supreme Court has defined the relevant status as that he was a felon. And in this case, it was stipulated that he knew he was a felon.
Your Honor, we can see that. There's no question.
Relevant status under Rahafe.
Your Honor, my position on behalf of my client is that the government had to prove a little more that he knew. Can you point me
where in Rahafe that supports it? Because I see multiple times them defining the relevant status as simply being a felon, or in that case, someone who's unlawfully in the United States. Can you point to me what language you're relying on in Rahafe?
Your Honor, what I'm relying on is the portion of Medley, which interpreted Rahafe.
It just said prohibited status, what you just read to us, which is no different from what I just said. And that is that you have to have the prohibited status, which is being a felon. I'm following the Supreme Court decision here. I'm not bound by the Fourth Circuit. And
I understand that, Your Honor. I agree with that. We take a somewhat broader view, but
So wasn't Medley vacated? Wasn't it vacated because it's on bank?
Your Honor, the last that I looked, 3 weeks ago, Your Honor, I was not aware since then of any change since then. I have not done anything on the case for I had throat surgery last Monday and was medicated, and so I did all the preparation before that, Your Honor. But I would like to say, Your Honor, it's entirely possible for a person to not know that being convicted of a felony divests them of the right to possess a firearm. With an election just having occurred, we saw that many felons have had their right to vote restored. And that could cause some confusion. And after the Supreme Court case decision in Heller, a case that started in this circuit, we as lawyers know that it essentially vacated the District of Columbia's procedures for retaining a firearm license. A person like my client, who one of the government exhibits at trial was a GED certificate on his wall in the firearm where the gun was found. He is not a highly educated person. And with the confusion about the state of the firearms law, he could readily believe, or it's entirely possible for him to believe, that he is no longer prohibited. And my position is simply that the prosecution never proved that he did know that. And so for that reason...
Mr. English, why didn't you file a reply brief?
Your Honor, I thought I would, first of all, I would say the Medley case that I'm relying on here now was not decided within the time frame for a reply brief in this case, Your Honor. And so that's essentially why I did not for this. But
reply brief because a case that didn't exist at the time the reply brief was due?
Yes, Your Honor. Medley was decided later.
Well, how did you know something was going to come up that you could use later?
Your Honor, the case laws that developed seemed to be more favorable. as the time went on. I didn't know that the case would be decided. I was aware of the Gary case, but Your Honor, I raised it when I became aware of it. And see, my time is about out. If it pleases the court, I will submit on the pleadings on the 404B issue.
Okay, thank you. We'll hear from the government now, unless my colleagues have questions.
No.
Ms. Carroll.
Thank you, Your Honors. May it please the court and Carol for the United States. As we argued in our brief, there was no, appellant took a contrary position to the admissibility, or excuse me, to the element at trial. Appellant conceded not only the fact of the prior felony, but that he knew that because of the prior felony, he was a felon and could not possess a weapon. That was in the course of the pretrial hearing on September, I believe it was 10th of 2019. I cite that specific colloquy in my brief. In addition, Your Honor.
But I don't think he didn't concede that he knew he couldn't possess a weapon, right?
I believe.
I don't think he had to. Did he concede that?
I believe that was the language. And if I could refer to that, because I did have it with me.
I thought it was a JA 307, but maybe I.
JA 60 was the pretrial hearing.
Pretrial hearing. I'm sorry. I thought you were talking about the stipulation.
No, the stipulation, of course, doesn't mention that his knowledge of the fact of the illegality. But appellant at the hearing stated one of the stipulations we've entered into today and signed that my client was convicted of a felony, and because of that, he knew he was legally impaired and could not have a gun in DC.
Got it.
So in addition to that concession, Your Honor, there has been no case that the government is aware of that has held that appellant must know, essentially, ignorance of the law is an excuse in the context of 922G cases. In fact, as Your Honors noted, Rahafe only required the additional element of the knowledge of the fact of the felony conviction, which appellant has never disputed, and was part of the indictment, stipulation, and instruction to the jury. So there is no error either by counsel or in the record, because the jury found the requisite element required by Rahafe.
Can I ask you? Oh, I'm sorry, go ahead.
Certainly, Your Honor, no, please.
If you were going to make some more on that point, go ahead, because I was going to, notwithstanding his submission, I had some questions about 404.
I was actually going to ask if there were any further questions on Rahafe. I would turn to the other issue. Would Your Honor want to ask that question?
Colleagues have more questions about Rahafe. I didn't mean to cut that off.
No.
Okay, so are you familiar with our case in the United States versus Sheffield?
Yes, Your Honor. We did cite it and touched on it very briefly in our brief.
Why isn't, let's start with the ammunition conviction, which was 11 years old.
Yes.
Why wasn't that stale?
So,
balancing.
First, Your Honor, appellant never challenged the admissibility based on staleness of either conviction. The only argument in the motion in limine that appellant made in the pretrial was that the 2008 misdemeanor conviction was not admissible under 609 for impeachment purposes. Appellant did not, appellant's analysis was strictly based on the fact that.
No, but he talks at the 609, he talks about the time limit there, and then says the same sort of prejudice analysis should apply here. So I think that imports the staleness principle here. We can argue about whether you should import from 609 or not, but that was his way of saying this is unduly prejudicial for those same considerations there, which included staleness.
Well, to the extent that an issue of staleness was raised at all, even 609 does not have a bright line requirement of an absolute bar of evidence before 10 years. Mm-hmm. And certainly under 403 and 404, there is no requirement that the prior bad act be within 10 years.
Talking about 11-year-old conviction, and yes. It was for ammunition.
Yes.
not for a gun, and ammunition for a different type of gun. Now tell me what on earth an 11-year-old conviction for ammunition for a different gun made more or less likely in proof of an element. How did it make anything more likely other than this guy's been around guns before?
Well, Your Honor,
That's it to me.
the relevance was the fact that the 2008 possession of ammunition was in the same bedroom in the same house where the search warrant was executed in this case. And as Your Honor is aware, evidence becomes stale at different rates depending upon the purpose for which it was.
But this is ammunition. It's not even a gun, and it wasn't even ammunition for the same type of gun. So I don't see how it made any, particularly even looking at a Linares type analysis, given all of your other proof. I don't see, if the jury thought the gun was planted, then it's not going to help you. And if the jury agrees that the gun that was in the drawer was not planted, that it was his, the ammunition's not going to do anything. It's just piling on propensity to have guns.
I would respectfully disagree, Your Honor. In this case, because the issue was both constructive possession, for two reasons. One, because the issue was constructive possession of evidence that was contained in the same bedroom. The probative value, and this court has recognized that the relevance of the prior bad act depends on the reason for which it's offered. And part of the reason was the fact that the defendant kept contraband, had secreted contraband in the same exact room where the evidence was recovered in this case. Under the circumstances of this case, the probative value didn't diminish with the age. The fact that the defendant had previously secreted evidence in the same location is highly probative that the defendant's ties to the evidence that was secreted in that location during the search warrant in this case.
The dispute, it was his room. So it made perfect sense that his ammunition from last time would have been in the room. So either they're going to believe that the gun was his because it was in his room, and you had plenty of evidence on a lot of evidence on that front, or they're not. I just don't see what the ammunition, particularly something that stale, and it's not even like you found another gun. It's sort of off point. It's very, very old. It seems to me to fall squarely within Sheffield on prejudice, and it did nothing other than show, like you said, he has unlawful things in his room. But that sounds like propensity to me.
Your Honor, the fact that he secreted evidence, and an ammunition may not be a gun, but it goes with a gun. And there was ammunition seized in this case. And the fact that it is, the defendant kept contraband in his bedroom, it was a disputed issue. Appellant challenged the constructive possession of the gun as well as the other paraphernalia. This court's analysis in other cases, such as McGill and other cases cited in our brief, where prior possession was relevant to show an intention to exercise dominion and control.
Not that old. That's the thing you got to grapple with here, is this is really old under Sheffield.
I understand, Your Honor, the age of the case, but when the point is the intention to exercise dominion and control over contraband secreted in the same location, that factor doesn't diminish with age. The fact that he kept—
If it was 20 years old, your position would be the same. There's no time limit. There's no staleness on that.
This is a question of residence, Your Honor. Just as in a search warrant—
Does that mean 20 years wouldn't matter? Are you arguing for no rule of staleness when you're talking about intent to conceal unlawful items?
Well, as Your Honor recognizes, everything is a fact. This is a fact-specific analysis, and Judge
I'm talking about your argument to me right now. I don't see you weighing the staleness fact at all. So I'm trying to understand from you how you weigh. I haven't heard you weighing it in there yet. How you would weigh it in there, or are you arguing to us, which sounded to me like your argument, and maybe that's your argument, that there's no staleness, there's no time limit in this factual scenario?
The purpose for which it's offered in this case, it was not stale because the purpose is the ties to that room and the ties of keeping contraband in that room.
When would it become stale? For this particular showing?
For this particular showing, I don't think it would become stale because it is a question of the ties to that particular room. As Your Honor has recognized in other cases, residence can go on for decades, and that is unique to this case that distinguishes it from Sheffield. I'd also note in Sheffield, it was the lack of further information about the context, which this court actually pointed as part of the reason why, under the circumstances of Sheffield, it was not probative in the 403 balancing. It did not outweigh the prejudice of the prior conviction. In this case, it was highly probative, particularly given the defense, the fact that Appellant challenged.
Highly probative of what? The ammunition from 11 years ago was highly probative that he possessed the gun?
That Appellant intended to exercise dominion and control over contraband that was secreted in his room.
Oh, the gun. You're talking about the gun or everything in the room?
I would talk about everything in the room, but particularly the gun, because it was secreted, it was in a drawer. It was not out in the open as the drugs were, but it was in a drawer. Now, as Your Honor noted, there was overwhelming evidence that went to the Appellant's possession. But in this case, as the court found in Sheffield and in subsequent cases analyzing it, that factor actually weighs towards the harmless error in this case.
Right, that's a different argument. That's a separate argument from whether or not 11-year-old convictions for something that's not even directly connected.
I would submit that ammunition.
403. I get your position on 403, but right. So you definitely have your harmless error analysis, which was really, really cursory in your brief. I was a little surprised.
Well, it was overwhelming evidence. There was I
mean, that's. I was a little uncomfortable because a lot of time we have circuit precedent that things that are sort of just thrown out there and not developed, we don't recognize as arguments. But I thought from reading the background that you would have a more substantial harmless error argument simply than just announcing that there's.
Well, and our argument was tailored to the arguments raised in Appellant's brief. And Appellant's brief on this point was rather brief. It talked about 609. It did not talk about Sheffield. Appellant did not cite Sheffield, did not raise this issue either in front of Judge Hogan. Judge Hogan did not analyze this particular issue, but found, based on viewing the facts that were at issue, that it was highly probative of the defendant's
harmless error now. So do you want to just give a minute on your harmless error argument so I can?
Thank you, Your Honor. Thank you, Your Honor. Yes, as Your Honor recognized, this was overwhelming. There was overwhelming evidence in this case. There was a fingerprint found on, I believe it was the slide as well as the magazine in this case that was identified as Appellants. There was evidence from both his prior conviction for quid cocaine that tied him to the drugs that was located in all the paraphernalia that was located in the room, and the testimony from the expert witness, which tied all of those items to drug trafficking. And the jury in this case certainly didn't misuse the evidence, but given its acquittal on count 4. Finally, Judge Hogan gave limiting instructions both at the time the stipulations were admitted, which again were very minor and brief references in the overall record, and at the time of final instructions. And I would also note that it was neither stipulation, both of which were admitted through stipulation, were large portions of the case. They were brief references, both at the time they were admitted and 2 paragraphs in the government's closing.
Is this a one-day or a multi-day trial? I'm not quite clear on that.
I believe that the actual trial may have spanned about 3 to 4 days, but the actual testimony took about, I believe, 2 days, and the jury returned a verdict after being retiring on the afternoon, returning the following mid-morning.
All right, thank you.
If there are no other questions, we'd submit on our brief and ask that Judge Hogan's ruling be affirmed.
Thank you, Ms. Carroll. Mr. English, we'll give you 2 minutes for your rebuttal.
Thank you, Your Honor. I respectfully submit this was a closely contested case, as evidenced by my client's acquittal on the 924C gun count, Your Honor. And regarding the admission of the misdemeanor ammunition possession case, we respectfully submit that was outrageous. My client's fingerprint was clearly found on the gun, and in this case, so it's difficult to see how it added anything of any probative value that was essentially was a character assassination attempt to show propensity evidence, which is prohibited, Your Honor. And for that reason, it should not have been done. And it's hard to say that it's a harmless error because who knows what affect jury. And we, in our initial motion in limine, cited the studies that show when juries are aware of a prior record of someone, they're much, much more likely to find them guilty for propensity reasons. And so we respectfully submit that evidence never should have been admitted in this case. And so in closing, let me say thank you for giving me the opportunity to argue on behalf of my client in this case. I appreciate your attention.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission. Mr. English, you were appointed by the court to represent appellant in this matter, and the court wishes to recognize your representation of appellant.
Thank you, Your Honor.
Case number 19-1050 et al. Martha G. Smith and George S. Lakner, appellants, versus Commissioner of Internal Revenue. Mr. Leyden for the appellants, Mr. Schuman for the appellee.
Good morning, counsels. Mr. Leyden, please proceed when you're prepared.
Good morning, Your Honor. May it please the court, my name is Edward Leyden. I represent both the Mr. and Mrs. Smith. Mrs. Smith is use a different name, but Mr. Martha Smith and George Lakner are married and have been for many years. This, as the court knows, is a case that arises from the tax court through the court's jurisdiction to hear cases arising from the tax court. It centers to a great, almost, I think, predominant extent on the admissibility of certain substantiating documents. As the record reflects, we really have two tranches of tax years in question, although they are sequential for reasons that probably don't bear on this particular analysis. 2007 and 2008 were the subject of an examination that commenced earlier on. 2008, 2010, and 2011 were added on. Because notices of deficiency were issued at different times, these cases were then consolidated for trial. And a trial did commence before Judge Lauber in September of 2013. At that time, Dr. Lakner, who was the primary participant in this, Mrs. Smith did not spend very much time on this and was not particularly involved with negotiations or discussions with the IRS, submitted to the court 4 boxes, banker boxes, full of copied receipts and canceled checks and things along these lines, and really, frankly, would have been difficult for the court to sort through. Judge Lauber, not surprisingly, said, go back and fix this. Now, what's interesting is from Dr. Lakner's perspective, and Dr. Lakner, as the record reflects, has had a cinematic life. He's a world-renowned psychiatrist. He's taught at Harvard, Yale, George Washington, Columbia, and around the country. He's also been a colonel in the United States Army, was on the VA, and before that, emigrated from Hungary after having participated in the 1956 uprising against Soviet rule. It's a background that is, as I think, cinematic is the best way to describe it. He takes the position now in his later years of his life, and all this occurred while he was in his 70s, that he had already provided those documents, the ones for 2007 in 2009 to the IRS through its Office of the Taxpayer Advocate, and only received them back just before the September 2013 trial date. And that was what he provided to the court at that point. Subsequent to that, I entered my appearance for purposes of tax years that were not at that point at issue, for which statutory notices of deficiency weren't issued until February of 2014. And I entered my appearance and filed a petition for those years and asked for consolidation with the other years. And as much as they're sequential and they deal with common issues and makes perfect sense as a matter of judicial economy. Those other years, 2008, 2010, and 2011, were also the subject of documentary evidence that Dr. Lakner, again, through his own testimony, submits he had already turned over to the revenue agent in question, but that which he contends he never received back. We have a classic question of credibility. And
you argue below to the tax court that he had turned over the 2008, 10, and 11 records to the...
Yes, he testified to that at trial, that he had and the government through its...
You don't have that?
Sorry, Your Honor.
Do you have a citation for that?
It's in the briefs, Your Honor. It was as a matter of trial testimony when Dr. Lakner testified during the tax court trial.
All the 2008, 10, and 11 documents, corroborating documents to the revenue agent and his...
That's what he believes happened, and that's what he testified to. In fairness, the revenue agent said that that didn't happen. And as a practical matter, that may not make much difference in the bigger scheme of things, because that's really the avenue of relief that we seek. I think Judge Lauber was quite correct in saying that a trial judge is not set up and shouldn't be expected to conduct what is in essence a tax examination based on original documents or copies of original documents.
That's not what I'm asking about. I'm asking about the argument at the end of your brief that there was somehow something sort of went wrong on the IRS end here, because all these documents that they say they need were turned over to the agent. Was that legal argument presented to the tax court? You said he mentioned it in his testimony. It was a legal argument that...
We did not know, Your Honor, because what we had asked for at that point was for leeway to present those documents. For Dr. Lakner, who testified as well, I should add, said he didn't keep copies of the documents that he gave to the revenue agent to go back and recreate those documents. What he had said he did was tape them onto 8.5 and 11 size sheets and make copies of them. And he was going to go back and do that again. At least that's what he told the tax court when he testified to doing. But we did not make a legal argument that there was some malfeasance or other untoward conduct on behalf of the government in this case. And the relief we're simply seeking is to be able to bring those documents forward, those substantiating documents. And the reason we say this is that there's a process to do that very thing, albeit at the tax court level. The revenue procedure that we cite, 2016-22, which came down March 23rd, 2016, provides a process by which that could happen, which is in fact probably the most logistically feasible thing to do would be to bring this down to appeals, where a subsequent examination of these documents could occur. And that would be the substantiating event. And the point being here that if this turns on a matter of substantiation, you either have background documents or you don't. In this instance, the government has taken it.
Is there anything in the record that shows that he did turn these? I know you said his testimony. Did he have any substantiating documents about handing these documents over?
No, Your Honor, he didn't have a receipt. He didn't have anything on the order of some kind of a confirmation note or anything from the revenue agent. And in all fairness, in the interest of full disclosure, the revenue agent's own case notes, which were admitted, I believe as 55R, don't reflect that encounter either. So in terms of where we're coming from here, we would not base our case on any misconduct on the part of the IRS. I don't think we need to go there, and I would be very reluctant to go there. Knowing the revenue agent in question, having worked with this agent before, and knowing the honorable nature of the IRS, having worked with the IRS for 30 years, I don't believe that that is a necessary analysis for this court of the tax court to do. I believe there is
about the payments that were coming from the VA, not the settlement one, but the other. I guess there were
104A4, Your Honor. Yes, the ones that.
Please let me just describe it here so you can tell me what I've got wrong. So I thought there were some monthly payments, although maybe I read somewhere it was only 5 months worth of payments that came from the VA. Can you explain to me, were these monthly payments that went on for some prolonged period of time or just for 5 months? And then what your best argument based on the record is that those were either, I guess, a disability or pension payments that would be excluded based on record evidence?
They are recurring. The nature of, I'm sorry.
Are they constantly?
Yes, they are, yes, on a monthly basis. It was a disability pension that Dr. Lakner was provided.
Were these monthly payments made?
I'm sorry, say again, Your Honor.
Over how long a period were these monthly payments made?
They were commenced, I believe, in 2010, and from what I know, they continue still.
Okay.
That this was, and the reason was because Dr. Lakner had been wounded in Kosovo, or instructed in Bosnia, and that this was in relation to the disabilities that he suffered as a result of that. And under 104A2 of the Internal Revenue Code, those types of payments are categorically held to be exempt from taxable income because of the nature of the income. And was distinct from 104A2. It's limited to military members or people in the armed services, which of course Colonel Lakner, or Dr. Lakner, he was a bird colonel in the Army, wounded in the course of combat, to which he was entitled.
And so you don't have any documentation, even over these years from the IRS. Do they, or not the IRS, excuse me, the VA? Do they not issue sort of any annual statements just explaining the payments?
I've not seen such a statement from my client, Your Honor. And I'm not sure that would actually answer the question. But what we had argued at trial was that because these, at least the way we characterize them and what Dr. Lakner was led to believe through a social worker would be tax-free, that would mean that they would never be reported to the IRS. That was the argument we made there. In other words, by virtue of the IRS own instructions regarding 1099 misissuance, that at least for 104A2 and by extension 104A4, that the IRS, a payor in any instance, the government as the VA or in any other payor for these purposes, is not required and in fact is discouraged from issuing a Form 1099, which we use as the explanation of why the government wasn't aware of these payments in the first place. When I say the government, I mean the IRS as opposed to the VA. Why they weren't aware, because there was no statutory reason for them to be so aware. There was no notice because these were non-taxable to the recipient and hence never entered gross income.
Thank you.
I'd be glad to, Judge Srinivasan, Judge Henderson, any questions you have, I'd be more than glad to try to answer them.
No.
None for me, but thank you, Mr. Layden. We'll hear from Mr. Schuman now.
Good morning, and may it please the court. My name is John Schuman, and I represent the Commissioner of Internal Revenue. Before I begin my larger outline, I'd like to start with two of the questions that arose from Mr. Layden's presentation. One of which had to do with whether these documents for 2008, 10, and 11 were given to the revenue agent and then supposedly not returned. There was some testimony about that at trial, and specifically it's at the appendix pages 310 and 311. And there Mr. Layden explained to the tax court that they did not have substantiation at the time to document that these were disability payments and not some taxable income instead. And that
payments
specifically.
I mean, what monthly payments does the VA issue to a retired service member that are not on an ongoing basis that are not disability or pension. What else? I mean,
Well, that's just,
government, you should know what the they don't just give out money for some other category that I'm aware of. If they do, let me know, because my husband's retired and I'd like to get the money.
yes, that you're absolutely right about that, Your Honor. But that's just it, though. That there wasn't really a showing that these were monthly payments that continued indefinitely in the same amount. There were actually larger payments. These were amounts that, again, coincided with the same time frame as the settlement with the VA. And of course, the settlement included items that were taxable income and that were not non-taxable.
I had thought the record showed from your, not your personally, but from the IRS's, what do you call it, the bank analysis, that they had identified, and it was confusing to me how long the period was, but apart from the settlement payments, they had identified a pattern of payments from the VA. Now, I had read somewhere and thought it was only 5 months, but Mr. Layden says it was ongoing from 2010. Did you find an ongoing, explain to me what they found. Put the settlement payments aside. There's a separate category here of VA payments that was found, as I understand it, through the bank deposit analysis. Is that what you were saying was in different amounts? Was that ongoing, or was it limited to a short period?
Well, the record is not crystal clear on this amount. The revenue agent did say that there were a series of payments, but it's not clear that they were the same amount every month that continued on. It's not clear that they were.
This is the Veterans Administration. And you've got someone that's undisputedly a retired service member. And if you see a series of payments from the VA, I just don't know on what possible basis you think the VA is making taxable payments to a retired service. What if you could just tell me something in the law that the VA pays that's taxable to former service members in a series of payments over months, that would help me. But I'm having trouble imagining what that payment could possibly be, except for one of the two non-taxable categories.
Well, the revenue agent did look into that and tried to determine that, and was not able to determine that it was a non-taxable payment. And
is there any such thing in your experience, in the IRS's experience? I mean, your personally, sorry, in the IRS's experience at the VA. This is what's baffling to me. I just don't know what the VA pays. He wasn't an employee at the time, so I don't know what they would pay on a recurring basis, other than something that falls within the tax exempt category to a former service member. Are you aware of anything that they pay that's not a former service member on a monthly basis, recurring monthly basis, that is taxable?
Well, it could have been related to the settlement because it was in the same time frame, and those payments were not necessarily made all in lump sums. Now, some of them were, but some of them weren't, and there were different categories of payments.
Well, have you added them? We know what the settlement amounts are, so have you added them together? Do we know that these were just settlement payments?
Well, he was definitely paid the settlement payments, but they weren't all in one payment. And I guess what I would go back to is that to prove a deduction or an exclusion from income, the taxpayer has the burden of showing that these were non-taxable in nature. And there was simply no documentation of this, although if it had been disability payments, I'm certain there would have been some documentation from the VA.
Preliminary, sort of very minimal showing, and then the burden shifts to the taxpayer. Is that not what the statute says?
Correct. Yes, we did show that the income had come in, and then it was up to and so it's presumed to be taxable, and then it's up to the taxpayer to show otherwise, that it's in a non-taxable category. And here there was simply no documentary evidence. There was no substantiation whatsoever, nothing that would convince the tax court.
Just one quick clarification. When you say it was presumed to be taxable, you mean it was presumed to be taxable because there was documentation that showed that these amounts were added to the bank account?
Yes, it was part of the bank deposits analysis. Yes, Your Honor.
And then that creates, the way this works is that creates an assumption that it's taxable income, and then the burden is on the taxpayer to show that even though there was money deposited in the bank account, that was actually non-taxable.
Right. Right, that's correct, Your Honor.
And I just want to be clear on one thing that because I had thought, and this could be my error completely, I had thought that there were sort of two categories of VA payments here that were at issue. One was a set of payments that was the settlement agreement. But that I had thought there was a separate argument that there were these other payments from the VA that recurred on a monthly basis. It wasn't clear to me how long they repeated, but they occurred on a monthly basis that were distinct from the settlement agreement. Are you saying I'm incorrect in understanding it that way from the briefing, that in fact, we don't know if there were any VA payments separate from the settlement agreement?
Well, the problem here is that in 2010, there were a number of payments from the VA, and taxpayer, even though he had the burden to do so, did not provide substantiation of what was what. So it was up to the revenue agent to try to figure that out without really any cooperation from the taxpayer. And he tried to do that and tried to determine if there was evidence that these were non-taxable, but he was unable to find that. And did
he do a bank deposit analysis for 2011?
Yes.
Were there monthly VA payments in 2011?
I'm not certain of that, Your Honor.
He's a retired military colonel, as we've been told, who presumably would be getting some sort of retirement benefits from the VA. Is that right? I mean, the government doesn't dispute his retired, or do you? The IRS doesn't dispute his retired status as a former military officer?
No, I believe we stipulated to his retirement from the Army.
And so he would be getting some monthly payments, would he not? Either disability or pension?
Well, that's what the revenue agent asked the taxpayer. That's what the revenue agent was trying to determine, and again, did not receive any cooperation, and so had to try to figure it out for himself. And he did not find that evidence, and the tax court, in a factual finding, determined that the substantiation was not sufficient.
This might be a crazy argument. Does the IRS, because y'all are one government, does the IRS ever ask a federal agency what the basis for payments are? Is that any part of an IRS inquiry like this?
I don't know if that's a routine part of the process. Ordinarily, the revenue agent is getting information from the taxpayer. That's the first source. That's the horse's mouth. So that's where they get them.
In this case, the whole reason you were doing the bank deposit analysis is you weren't getting much from the taxpayer. And I'm just wondering why this could have been cleared up quite easily. And since he's a retired service member, I should think the IRS would be aware that it's likely that he's getting pension or disability payments from the VA. And so just to sort it out, wouldn't it have been, there may well be a reason, please tell me why, but wouldn't have been to this non-IRS person here, it would have been probably logical and pretty easy thing to do is just ask the VA.
Well, we did have information about the settlement and about the non-taxable items, but again, there was no cooperation from the taxpayer here, and the commissioner's determination of tax liability, as set out in the notices of deficiency, are presumed correct under case law, and taxpayers have the burden of proving them erroneous. So they had that burden, as well as now in this court, the burden of showing that there's a definite and firm conviction that this factual finding by the tax court was a mistake. And I submit that he cannot meet those burdens. The other item I was going to discuss regarding the case was that on pages 310 and 311 of the appendix, the taxpayer testified at trial that he could have regenerated these documents from 2008, 2010, and 2011. And he simply didn't do so, didn't submit it to the court. So we have their ability to submit these documents, but not the fact of them having done so. I see my time has expired. I'm happy to answer any further questions or present a broader picture of the case than these two elements.
There was in all the assorted receipts there were some utility bills for Connecticut and California. Why is a utility bill from a state in which you reside, but in which you have a rental property, not a relevant, the bill itself, relevant evidence of a payment, a deductible rental income payment?
Your Honor, this item was not raised by taxpayers on appeal in this court, and I think they've waived all objections to the specifics of this. But we did address this in tax court in the respondent's answering brief after the trial, and we went through each and every element of the deductions for those years that were claimed, including utilities, and indicated why they could not, why there was a lack of substantiation as to each one of those items. And
unfair since it wasn't specifically briefed by them. Do you recall what the rationale for the utility bills was?
Your Honor, I could look that up in our brief below, because we certainly did address all of that, line by line and item by item. I don't recall exactly what it was for the utilities. If you could.
That's okay. That's okay. That's fine. Okay. It's perfectly understandable. You said they didn't raise a specific argument. Yeah. Thank you.
Make sure my colleagues don't have any further questions for you, Mr. Schuman.
Okay, thank you. And I ask that the decisions of the tax court be affirmed. Thank you.
Thank you, Mr. Schuman. Mr. Layden, we'll give you 2 minutes for rebuttal.
Very well, Your Honor. Thank you. I'll just try to answer some of the questions that Judge Millett raised, and also to address Mr. Schuman's point as regard to out-of-state expenditures. Mr. Schuman's quite correct that in 2010, there were some of the payments for disability were lump sum payments. There were makeup payments in that period that then became monthly afterwards. And that was a reason why some of that was in amounts that weren't recurring at that point. It was that these were made up, making up for past periods that had not been covered for whatever reason. Dr. Lakner had not received them. So that explains, I hope, or at least addresses the nature of the payments. In terms of these out-of-state expenditures, along with all of the rental expenses, that's sort of our point. And I think we did raise it to the extent, I know in the briefs we talked about that these were places where Dr. Lakner didn't live. We all agree he lives in DC. And so to characterize them as the service did as being personal expenses just didn't make sense. At the end of the day, what this boils down to is there are records here. No one, because they've been described as being disorganized, has really looked at them. No one at this level, certainly not the appellate level, certainly at the trial level, should have to. That's why we have an appeals office, and that's why we have revenue agents. So what we're asking for as relief is the opportunity to have someone take a look at this. Now, as respect to the point as to why these 2008 through 2011 receipts were not issued, we asked for the court's permission to do that. That record, the tax court record, shows that we did make that request before the court's final determination and were denied. That's the reason they were not submitted, because the court would not grant us leeway to open the administrative record to receive those documents. Again, I thank you. I'll be more than glad to answer any questions. Just in conclusion, we would ask the court to reverse the tax court and to submit for, at our point, the remedy we seek is referral to the IRS Office of Appeals for further consideration of these years under audit.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Thank you, Your Honors.
This honorable court is now adjourned until Tuesday, December 8th at 9:30 a.m.